Thank you for joining us today. We are going to get started in 1 minute.
Welcome, everyone. We'll start in just about another 30 seconds or so. All right, everybody, I think we will go ahead and get started. Thank you so much for being with us today. I'm Jennifer Mnookin, and I have the great fortune of serving as Dean here at UCLA School of Law. And thank you for being with us. Before we begin, I would like to acknowledge that UCLA School of Law sits on the traditional, ancestral, and unceded territory of the Gabrielino Tonkawa peoples. As members of a land-grant institution, we at UCLA pay our respects to the ancestors, elders, and relatives, past, present, and emerging. I'd like to now welcome you to the latest installment in our From the Front Lines virtual series. In these uncommonly challenging times, we're very lucky at UCLA Law School to have faculty, alums, and friends who are among the foremost experts in so many of the legal, social, and political issues that are at the heart of the current conversations. For today's discussion, The Future of DACA, a conversation about the recent court decision and what it means for immigration policy. We're particularly lucky to have experts at UCLA Law School who are part of our new Center for Immigration Law and Policy, as well as with us today, a law school alum who works on this very issue. And I know this is going to be a really interesting conversation to help us think about the current moment. As many of you are probably aware, on July 16th, a federal judge in Texas declared the Deferred Action for Childhood Arrivals program, otherwise known as DACA, illegal, beyond the authority of DHS, and ordered the agency to halt the processing of all new applications. The Biden administration said that it would appeal the decision, but has declined to seek an immediate order staying it. This decision will impact the lives of hundreds of thousands of young people, and it could potentially have lasting effects on our immigration system. And so today we're going to dive into this. We'll hear about the origins of DACA, some firsthand accounts of what's happening on the ground, a little bit more about this opinion, and what might happen next. I'm delighted to introduce and moderate the panel today. My introductions are going to be very brief, but you can look at the program for more detail on this very distinguished group of speakers. First, please welcome Ahilan Arulanantham, professor from practice and co-director of our Center for Immigration Law and Policy. Welcome, Ahilan. Next, please welcome Hiroshi Motomura, the Susan Westerberg Prager Distinguished Professor of Law and also the faculty co-chair of the Center for Immigration Law and Policy. Welcome, Hiroshi. Next, please welcome Nina Rabin, the director of our Immigrant Family Legal Clinic. Welcome, Nina. And last but certainly not least, I'm very pleased to welcome proud double Bruin alumna Ignacia Rodriguez Camex, class of 13, and immigration policy advocate at the National Immigration Law Center. Thank you so much for joining us today as well. Again, it's a really distinguished group, and I haven't told you very much about their accomplishments. So look in the chat for the link to today's program, and you can read more about their backgrounds. If you have questions, and I hope you will, please feel free to send in questions through the Q&A function on the webinar, and we will take up some of your questions too in the course of our conversation. Nina, I'd love to start with you, if that's okay. And I'd love to have you start by explaining what DACA is and does. I know some of our panelists are very familiar with it, but some are not. And then I'm probably going to ask you a follow-up that starts to link to your own work.
Great. Yeah. Well, thank you so much for inviting me to join this panel. And yeah, let's just get some of the basics out of the way so everybody's on the same page. So DACA, as you mentioned, stands for the Deferred Action for Childhood Arrivals program. And it was created by President Obama by an executive order issued on June 15th of 2012. And it gives those who are eligible temporary protection from deportation. So not a form of lawful status like a visa, or certainly not like a green card would, just a reprieve from deportation. And along with that, you get work authorization and a social security number. It has to be renewed every 2 years at a cost of $495. And to be eligible, you have to show that you came to the United States under the age of 16 and that you've lived here continuously since 2007. You also have to be currently in school or have graduated from high school or have a GED or have been honorably discharged from the military. And you can't have been convicted of certain criminal offenses. So that's just the very broad outlines. There's a lot to say about actually many of those eligibility requirements, but we can get into that in Q&A. And just really quickly, I wanted to add a few numbers just to understand the scope of it. Since DACA was created in 2012, over 800,000 people have received DACA. And as of this past March, there were just over 600,000 current DACA recipients. And California has by far the greatest share of any state. So over 1 in 4 DACA recipients live in California, about 175,000 current DACA recipients. So that gives just some general outlines of the program.
Thank you. That's really helpful. And I think the numbers are really helpful too for giving a sense of scope and scale. I'd love to ask you one follow-up before moving across our panelists. You lead our Immigration Family Legal Clinic, and that gives you the opportunity to work with members of our community who are seeking assistance with their immigration status. I'd love you to take that perspective and share a little bit more about what you're seeing on the ground. How has DACA played out in the lives of the young people you work with? And maybe how are some members of the community with whom you work and collaborate, how are they receiving this decision?
Yeah, great. So, I mean, it really has been quite a roller coaster on the ground where our clinic is located. So we are, the Immigrant Family Legal Clinic is located in the RFK Community Schools, which is a campus of 6 LAUSD schools serving about 4,000 families, grades K through 12 in the Koreatown Pico Union neighborhood. And when our clinic opened in 2018, Trump had actually rescinded DACA. So it wasn't a central focus of our work. We were mostly focused on outreach and education that was really defensive in posture, talking about what to do if ICE agents show up at your door and what benefits and services families could safely apply for. So when we saw DACA, it was mostly those lucky seniors or recent high school graduates who had applied before the program was rescinded and could now apply for renewals because of a court order that required renewals to continue. And so an example of DACA work during that time was we had one of our first clients was a recent high school graduate who had an extremely low level arrest, and he had to assess whether or not to renew. So he had to weigh the benefits of maintaining DACA against the very real risk that a renewal application, even with this very minor arrest, could suddenly thrust him into removal proceedings because of the aggressive enforcement agenda of ICE at the time. So in the spring, this past spring, it was wonderful to shift from this kind of defensive orientation to more affirmative, empowering topics for our outreach. And one of those was DACA. So over the summer, the court had ordered DACA to reopen for new applicants. And we made a big push to get the word out about DACA in the school. And there were a lot of 15 to 17-year-olds in our school who were eligible to apply, but understandably, families are nervous after 4 years of avoiding any contact with the federal government to submit all this information. So we did a week-long series of what we call DACA days, which were videos and Zoom sessions in classrooms and in the evenings and weekends for parents. And this outreach push really brought home to me just how many lives DACA has changed. We had a teacher in the school who was a DACA recipient who volunteered to participate. We had one of our own law students on the team was a DACA recipient. Another one had a sibling who had DACA. So we were able to put together this short series of videos of these individuals reflecting on how DACA had changed their lives. And then we met individually with high school students in breakout rooms to screen for eligibility and discuss next steps. And so it was a really energizing and exciting outreach effort. But all of this came to a halt last month when, as mentioned in the introduction, a federal district court in Texas yet again halted the program from accepting new applications. And I think later in the panel, we'll talk about what this means both for current DACA recipients and potential applicants. And it's definitely not, the fight is far from over. But in thinking about how it affects how we handle outreach and counseling about DACA in the school, it's really made me think about how much we ask of immigrant families to trust in the government when it's been so utterly unreliable. For nearly its entire 10-year history, for all of its amazing success stories, DACA has never truly freed young people to plan their futures without fear. And there are many real ways that it's really profoundly changed the lives of students and young parents in our school. But I think this most recent legal setback for me really shows just how fragile and incomplete a protection it offers. So I'll stop there and look forward to hearing from the other panelists.
Thank you. Thank you for giving us some sense of these dynamics that you are seeing on the ground. I'd love to turn to you next, Hiroshi. I'd like to invite you to both take a step back and retrace the origins of DACA a little bit from a student-led movement to an executive action by the Obama administration, and maybe situate this recent judicial ruling within that.
Yeah, thanks. And thanks for everyone for being here today. I'll try to explain a little bit about DACA from this perspective. I think that DACA really reflects several parallel stories. And as I look at the debate, leaving any of them out will mean the picture stays incomplete. And as I look at the debates about DACA, both in the policy realm and in the courts, I think that the reason people disagree about DACA reflects which parallel stories matter to them. So let me identify what they are, or try to identify what they are, and then I'm sure we can talk about this more as the discussion goes forward. But one way to tell the story of DACA is to think about this in terms of legislative activity. The DREAM Act is legislation that has been around as a proposal for 20 years or so, but it came closest to passage it comes to close passage several times. But the one I'm going to highlight right now is late 2010, but it stalled in the Senate even though it got 55 votes, And at that point, the question really was, is this something that Congress is really going to do, or is it really something that leaves room for the administration to do? Not to do what Congress declined to do, which was to enact full legal status and green cards and pass citizenship, do something else. And so that became the question of whether or not the administration would adopt what's called administrative relief as the prospects for legislative changes waned. And I think a lot of people who wanted the DREAM Act to go forward were really uncertain about this. But in other words, is it somehow giving up on Congress? But it turned out that this ended up becoming very much a moment for student-led movement to take hold and to really push forward and say, if Congress isn't going to do this, we can at least talk to the administration and get to do something, not what Congress would do, but to do something else, which ultimately became DACA. And so, the Obama administration was initially resistant, claiming there was no legal authority to adopt a program, but ultimately changed its mind, and it announced in May 2012 that DACA would be implemented as it was in August 2012. And this is really the program that Nina described. And so telling this story makes it seem like the Obama administration stepped in where Congress declined to act. And this is the story, I think, of DACA that is told or underlies the recent federal court decision in Texas. It's really the idea that Congress didn't act. What's Obama doing to step in and doing what Congress declined to do? And there's a couple of things wrong with that story, but one of them I think is something Nina alluded to, which is that this is a temporary reprieve It's not giving someone a green card or permanent resident status or passive citizenship, but it's also only half of the story. I think it's really important to think about how the DACA came about in a different perspective, which is how does any administration deal with an immigration system that's resulted in, among other things, a very large undocumented population, which has grown to 10 million or so people, but it's something that has not happened in one administration. It's been over 50 years. And so we have a system in this country of huge labor market needs, very selective admissions, not that many lines to stand in, so to speak, and very selective enforcement and vast discretion. And so the Obama administration sought to regularize prosecutorial discretion and to say, okay, we have very limited resources, we have a large potentially removable population. But the concern really was that the power of the federal government would be used haphazardly without oversight and possibly result in discrimination or improper enforcement against a large undocumented population that emerged over several generations. And so the Obama administration, especially in 2011, tried to issue guidelines to rationalize the application of limited enforcement resources, identifying high priority cases for deportation, and says, let's focus on those. And so there are memos for that purpose. It turned out that the rank and file of ICE officers and field officers of ICE resisted efforts to regularize the exercise of this discretion. The union refused at first, a union of ICE officers refused at first to let its members attend trainings on the guidelines. And so what this really is not just a story of the administration doing something partial in the interim while Congress was continuing to debate this as it does today, but also sought to rein in rogue enforcement, especially to limit the risk of racial discrimination and enforcement. And I think that's a very important way to think about what DACA does. It's really a attempt to ameliorate some of the injustices of an immigration system that creates a large population against whom immigration law can be enforced, but you're never going to know if you don't have regularization of the system of enforcement, you're never going to know if there's discrimination in policing that's going to go undetected and unremedied. And so the context really here is, what does it mean to be applied, for a law to be applied fairly? And so that's a parallel story to the story of the Obama administration stepping in a very limited way after 2010, when Congress had essentially gotten the 55 votes but not reached the threshold of 60. You're on mute here.
I was still muted. Apologies. Thank you for that. The context and the background. It can't be a Zoom webinar unless somebody does that at least once. I think but I'm sorry that it was me. Ignacy, I'd love to invite you to weigh in on this as well. You've been active in this movement, and I have another different follow-up question for you, but I'd first just like to invite you to sort of comment on the movement that got us to this point and your thoughts and experiences.
Thank you. I'd love to. So from my perspective, being an immigrant student activist at the time, there was a lot of really great organizing happening. A lot of momentum was building at the time for what we hoped would be the passage of the DREAM Act in 2010, but ultimately led to the announcement of DACA in 2012. We were building more and more of a public presence, for example, by the formation of a national group of immigrant youth, now known as United We Dream, and also the increased use of social media. There were more and more people willing to share their stories and willing to engage in civil disobedience. We went from doing mock graduations with permits and only being able to march on sidewalks to people literally putting their bodies on the line, having sit-ins in legislators' offices, in front of federal buildings, including the Wilshire Nine, when they sat in the middle of Wilshire obstructing traffic in front of the federal building, very close to UCLA. And so people were literally risking arrest and deportation. All this momentum made it so the administration, the government knew that if we couldn't get a pathway to citizenship, then something something needed to be provided to us. But President Obama had said in various occasions that he didn't have the authority to do so. And so that's when, as a movement, we came together to provide a blueprint for what the program would ultimately look like. And that involved immigrant youth activists meeting with UCLA law alums, including Shoming Shear, Nicolas Espiritu, to name a few, to think through, is there a temporary protected status like programs that can be offered to immigrant youth? And then it also required them being told what the legal authority is for this decision, this program being announced, which Hiroshi played a huge role in getting over 50 law school professors to weigh in and say, Obama administration, you do have the authority to do this. But it was definitely a group effort. And in the chat, we'll include a link to a book, Undocumented, Unafraid, that actually goes further into the topic, just because my remarks are focused on what UCLA did, but there were efforts happening across the nation.
Thanks. Thank you. That's terrific. And you know, congratulations on your advocacy and the effects that it did have, even if it wasn't all, you know, even if it was DACA rather than the DREAM Act. I'd love to sort of turn to stick with you for just another minute, Ignacia. And you know, you're currently working on the front line. What does this decision mean for DACA recipients and those who plan to apply? What advice are you giving people now? And what are your thoughts about what's likely to happen next?
Thank you. So in the chat, we'll add United We Dream's guidance, which was created with the help of direct legal service providers, who are the ones who are really on the front lines working with DACA recipients and requesters every day. So I highly recommend reading the guidance, and this guidance was updated since the decision in Hanen's court, since USCIS updating their FAQs. But I also recommend following NILC, United We Dream, USCIS, and other trusted sources of information on social media, and visiting their websites, because there's a lot of developments happening in DACA. And so the guidance that I'll go over briefly today may change as litigation continues. And also, we are waiting for the federal government to issue its proposed rule to strengthen and fortify DACA. So our guidance may change depending on what happens next. So the guidance I provided does go into specifics, but here's a list of the most popular scenarios people may be in and the corresponding advice. If you've never had DACA and have never requested DACA, but you know you're eligible, we recommend you speak to an attorney or a DOJ accredited representative before submitting a request for initial DACA. Based on Judge Hanen's order, no first-time initial DACA requests will be granted at this time. USCIS may still accept your initial DACA request and payment, but as of now, it'll just sit there. USCIS won't start looking at its content, won't approve it. So a consultation with an attorney will help you better understand the benefits and risks of applying as a first-time applicant now. If you have a first-time initial DACA request in the middle of processing, but it hasn't been approved yet, then Judge Hanen's ruling that USCIS can no longer grant DACA to new DACA requesters also applies to you. And your application, even if you already had your biometrics appointment, will remain pending, not approved. If you currently have DACA, your DACA and work permit are still valid. First-time initial DACA requests that have already been granted, already been approved, as well as renewal requests that have already been granted will continue to be valid for now. Just make sure to apply timely for renewal, meaning 120 to 150 days before your current DACA expires, and consider possibly applying even earlier than that to avoid any lapse in your DACA and work permit. The consequences of your DACA lapsing remain the same. You lose protection from deportation, possible job loss, etc. But if your DACA lapsed for a year or more, per USCIS's instructions, you have to request DACA renewal as an initial request. And now, due to Judge Hanen's order, your request is considered an initial request, not a renewal request, and will not be granted. Again, this is only applicable if your DACA expired, but you did not request a renewal within 1 year of its expiration. If a few days, weeks, months pass since your DACA expired, you can still apply and be granted DACA renewal for now. So rather than worrying about how long it's been since your DACA lapse, renew timely before your current DACA expires, and USCIS will continue accepting and processing DACA renewal requests until there's a court order saying otherwise. And in the chat, we'll add communication from USCIS stating so that you can refer people you know who are in the situation too. As far as what comes next, well, there is this opportunity for Congress to take action and to finally give us the DREAM Act that we've been hoping for and relief for a broader population. And we're hoping to do that through the reconciliation process, which is expected to really kick off as early as this Saturday.
Great, thank you. And thank you for that very direct and practical advice for anybody who may be on this call and either working with or facing these issues directly. I really appreciate that. I want to turn to you next, Ahilan, and really take up from where Ignacia left off. So, you know, what happens after this court decision? What do you think? How do you think this is going to play out in the courts? And what kind of legislative opportunities, if any, do you think this decision in this moment creates? Welcome your thoughts.
Yeah, thank you, Jennifer, and thanks to everybody for providing all this really useful information, important information about the state of DACA right now. Yes, as you had alluded to at the beginning, the Biden administration said they would appeal, but did not seek a stay. I was a little bit surprised actually that they didn't seek a stay, particularly on the geographic scope of the injunction. As Ignacia was describing it, the effect of this injunction is to set DACA policy nationwide, but it's in a lawsuit brought by Texas. And it's particularly interesting because there's actually a case in New York, Batalla Vidal, where there's a certified class of all DACA holders and all people eligible for DACA actually nationwide, a nationwide class. And that court had issued an order reinstating DACA and ordering the government to take new applicants as well as renewal applications for that nationwide class. And this had happened actually right before the Biden administration came into power. So you see an obvious tension, right, between that decision and this decision. And this decision is sort of splitting the baby a little bit by saying, well, you know, the existing renewals for people can be continue. New applications can be taken. The agency can take them, but they're not allowed actually to process them and grant them. So there's obvious tension here. I would have thought that perhaps the administration might have been interested in taking a crack at seeking a modification of that injunction to allow people in places like New York or California, obviously, to continue to seek DACA in the first instance, but they did not do that. It's also for the sort of legal realists in the world, during the Trump administration, there was a lot of criticism, including among judges and Supreme Court justices, Justice Thomas in particular, of what they call universal injunctions. This idea that one district court, without having a nationwide class in front of it, can set policy for the whole nation. And this was actually a concurrence, Justice Thomas wrote in his Trump v. Hawaii decision, saying, you know, there shouldn't have been these decisions striking down the entire Muslim ban. There was another similar criticism by Justice Gorsuch in the public charge litigation, also immigration litigation. Now it seems nobody's worried about that anymore. So I'm not sure what's happened when the shoe's on the other foot. So in terms of predicting, obviously it's tea leaf reading like anything else, very difficult to say. But the Fifth Circuit was very hostile to the broader program, DAPA, the program that the Obama administration had put in place for the parents of U.S. citizens, struck that down. So I think it's certainly possible that the Fifth Circuit could affirm this decision and rule that DACA is illegal, as the district court said. Then in the Supreme Court, it could get very interesting. The Supreme Court famously preserved DACA right last year in the Regents' decision, but did so on a procedural ground. They didn't comment on the underlying legality of the program itself, which is why this district court decision was able to come out and say that DACA was illegal, but found on procedural grounds that the Trump administration's termination of DACA had violated the Administrative Procedures Act. Now there's certain things in that opinion suggest that maybe they think that DACA itself is unlawful. The Supreme Court might well think that. It's possible. Obviously, the composition of the Supreme Court has changed since that decision as well. But there's also a procedural ground lurking here too, which is whether Texas has standing to challenge DACA. And standing doctrine, for the the lawyers out there who sort of follow this stuff would know, it's notoriously malleable. It seems that you can't make heads or tails of why some people have standing and some people don't, particularly in the recent times in the Supreme Court. But Texas lacked standing to challenge the Affordable Care Act. That was the ruling recently. The Affordable Care Act case. They also lacked standing to challenge Pennsylvania's election certification process. In Texas v. Pennsylvania, when they tried to, that was sort of the stop the steal litigation. So certainly it is possible. There's a more than non-frivolous argument. There's certainly an argument to be made that Texas doesn't have standing to challenge DACA, but it's also certainly possible that the Supreme Court could find that DACA is illegal as well.
Wow. So there's another procedural hook. If it got all the way to the Supreme Court and they wanted to avoid the substance, there's a pathway where they could probably do that, is what I'm hearing. But whether they would want to or choose to, or what they'd say about the substance is anyone's guess. Let me open this up to anybody, any of the panelists who'd like to answer it. I guess I'm interested in what you think this decision, what effects do you think this decision has, if any, on the legislative moment, on legislative opportunities that would provide a path of citizenship, either for those who are directly covered by DACA or potentially somewhat more broadly? Does this create a sort of greater impetus for this? Does it create any political openings? Or does it just turn it into another culture war issue and maybe make it harder? What do you all think?
I'm happy to start with that if
Sure.
others don't mind. I think it definitely creates impetus, and I've seen that actually. It's definitely created momentum towards a legislative solution. As others said before me, just this constant living your life in this uncertainty. You never know what's going to happen with your immigration status, from administration to administration, court decision to court decision. It just underscores how sort of absurdly unfair it is in a way to have to live your life this way. However, as Ignacia had mentioned, this issue kind of falls into the middle of some of the biggest legislative kind of questions of our day in the moment. There's on the one hand, there's more than 50 votes for the DREAM Act. That's been true probably since 2000, certainly since 2010. And in 2013, there were 68 votes for it in the Senate as part of the big immigration bill, but it couldn't get through the House. And today, there's more than 50 votes for it, and it's passed the House already, but there aren't enough to break a filibuster. So if there's filibuster reform, one effect that could have is you could pass the DREAM Act. The other way, which Ignacia also had mentioned, is reconciliation. And there's a very sustained effort going on now, leading up to what is going to be a ruling of the Senate parliamentarian on whether or not legalization bills that give immigration status to people have a budgetary effect, and therefore are within the essentially budget reconciliation exception to the filibuster. Because if you can pass a budget bill with 51 votes in the Senate, you don't need the filibuster-proof majority because of this rule that was created, which says that budget bills can go through that way. I should add here, Jennifer, this is of huge import, not only to the 650,000 or so DACA holders and other people who are eligible for it, but to a whole load of other people as well. I mean, most importantly for me, I'm personally interested in, is the temporary protected status holders, who are about 400,000 people who have lived here as long, in many cases, longer than DACA recipients, 20 years, more than 20 years in many cases, have had work authorization and lawful status during that time. And then the Trump administration tried to take away that status. And actually, the Center for Immigration Law and Policy is now doing a lot of work related to TPS, in part because I represent the TPS holders in litigation. They too have a path to lawful status, and almost certainly the majority they needed to pass it in the Senate if their bill can get through reconciliation. That's called the Promise Act, or if there's filibuster reform. And then President Biden has said that he favors similar legalization for farm workers and for essential workers, and several million people, not the sort of comprehensive immigration reform, sort of larger sets of people that have been discussed at times in the past, but several million people who would have a chance to get lawful status, work authorization, and a path to citizenship, that all could obtain legal status potentially, depending on these arcane Senate rules and whether or not these bills can get through one way or another. So all of that is in play, and I think has all been sort of brought even more to the fore as a result of this decision in Texas.
Thanks, Ahilan. Anyone else want to add to sort of this? Any contrasting or additional views about legislative opportunity and possibilities, whether through the reconciliation process or as a freestanding bill?
Yeah, I mean, there's just a couple of things to add here. That this is the tension that we had, a decade ago, really, between pushing for something that will be legislative and at the same time to see what can be done within the framework of DACA itself. And so this is the political dance of trying to not appear to be giving up on legislation. We could try to make sure that DACA survives as DACA. And so I don't think they're inconsistent with each other, but I think that there's a bit of a political hydraulic sometimes, depends on the person you're talking to. One thing I should mention is the Biden administration is working on proposed regulations that would correct some of the problems that Judge Hainan identified in the Texas decision, in his Texas Federal District Court decision, proposed regulations. One of the reasons that Judge Hainan found DACA to be unlawful is that the Obama administration did not go through the notice and comment rulemaking that the APA requires for certain types of regulations. The position of the Obama administration at the time was that this is a policy guidance that is not subject to those requirements. Now, if the administration were to adopt regulations, that would address what Judge Hainan said with regard to the procedural requirements of the APA. But the Judge Hainan went further and said, well, since I know that the Biden administration is thinking about doing this, let me tell you what's going to happen if they adopt regulations. And he said, I still don't think it's legal. So that's something that's going on, so that there could be new life given to the administrative piece, which may or may not have consequences on legislative momentum. The other thing I should mention is when the Supreme Court rejected the Trump administration's attempt to rescind DACA, one of the things it talked about was what DACA really does, and it distinguished the not arresting and deporting people, what it called forbearance, from the fact that people became eligible for work authorization. So it hinted that it may end up deciding that as a matter of prosecutorial discretion, an administration can adopt regs, or even without regs, have a forbearance policy, like people will not be arrested, people will not be detained or deported, but somehow make the argument that that does not necessarily mean someone can be given work authorization by the executive branch. I don't agree with that solution, that resolution and way of thinking about DACA, but for reasons having to do with the history of work authorization and the legal structure by which work authorization has been established. But I just want to point that out, both as what the administration is going to do with the regs, what a court could do with regard to the question of legality of DACA. And also, again, this complicates the question of legislative activity in the next 6 weeks, something like that. We'll see quite a bit in the months of August and September.
Thanks. I mean, you sort of touched on this, but we have an explicit question about it. And so I want to invite, I mean, if you could put anything you wanted to into the budget reconciliation package, right? Like if you could insert something in that process, what would you do? What type of provision do you think could be included and get through? What would you aim to do? Question from one of our attendees.
I can answer again. I'm very curious to hear what Ignacia has to say on this subject as well. Actually, do you want to go first, Ignacia, and I'll add on? Or?
Yeah, sure, gladly. So given the context that we're in, the first fight is to make sure that the money that has been allotted for legalization remains for legalization. And that's the first fight, right? Making sure that money doesn't get distributed elsewhere. That's what we expect those conversations to happen as early as Saturday. So we definitely want that money to remain. Second comes the question around who would this benefit, right? Immigration relief to whom? And while our aim is still, 11 million undocumented people, given the context that we're in, we're definitely prioritizing DACA recipients, TPS recipients, farm workers, and essential workers. And we're asking for the broadest definition of essential workers possible. So that would be the ideal situation through this process. And it happens through this process, we hope, because yes, the opportunity for standalone bills may be available to us after reconciliation, but the chances of them passing for the reasons and the numbers that Ahilan mentioned are very hard for us, given the political context that we're in. Ahilan, what are your thoughts?
I concur with all that. I would just say if the question was, Jennifer, like if you could do anything, what would you do? Ignacio's idea, 11 million undocumented people, that's sort of been the what many people in the immigrants' rights movement have talked about for decades. Another idea, which is an interesting idea, I don't think it's going to pass in this reconciliation bill, but it's interesting, is updating the concept of the registry, which is a really interesting idea that people don't necessarily know a lot about unless you follow this stuff closely. But for years, the immigration laws have had a provision. There's a provision in it today that if you've been here for a certain amount of time and you don't have a certain criminal history, then you can, quote unquote, register as a lawful resident of the United States. And essentially, it's something like a statute of limitations. Like, after you've been here long enough and the government hasn't pursued you and you've built your life here and all that, then you can stay. And that idea has been in our law for ages. And it's even in the immigration law today, but it hasn't been updated to reflect the date since I think it's last updated in 1986, and the dating is 1972. So if you've been in this country undocumented since before 1972, you too can today just like go and register. But of course, there's like nobody, that's a very, very long time ago. Updating that would be a way of kind of rationalizing our immigration policy so we don't end up in this position again and again, right? Where you constantly have people living in the shadows. And it would be, in my view, a recognition of a reality, which is, being here undocumented is not the most important thing that the government should hold against you for your whole life under any circumstances. That's not the way our immigration law has always functioned. There were people who talked about this a little bit in the lead up to the legislative process, but for reasons Ignacio says, I don't think that has the political context is not such that that's going to fly in this moment. But if I were writing the law, that's something that I would probably put in there.
I just want to build on one quick point from that, which is that, this question about who gets legalization. I think one of the, really disturbing aspects of the DREAM Act and DACA from the very start is the way that it can so easily be flipped to kind of vilify parents and to divide up families. And, we really see that on the ground in the school where you have these, one intake after the next of, parents who are coming in to help their kids apply for DACA or for other, and they're out of luck, and they have been working, for decades to support their children. They're so happy about it. They're like doing all of the legwork to get the application in, and it always just feels like, and I think DACA recipients have been, first in line to say this isn't right. Our parents need protection too. But I think that these legislative battles inevitably start carving up the population in ways that are, really destructive, even at the family level, where you really do have these divisions, in a school like where we are, where there's so many mixed status families, you really see it right there at the individual family and household level.
Yeah, thank you for that and for sort of helping us get a flavor for the challenges and the divisions that these rules create. I'd like to sort of take this back to you, Ignacia. I know you spent part of your own life undocumented, and although I think you're a citizen now, but I mean that makes you very well situated to talk about some of this in a slightly more personal way if you're game. Your own experience or how these structures and labels and opportunities matter.
Yeah, absolutely. I mean, I can focus on the practical implications of immigration status based on my experiences and checking my privileges, because I was able to qualify for family immigration relief after being undocumented for many decades. And I'll focus on that, but I do want to note that there is a psychological, like mental, real effect of your immigration status being able to determine your life options. So for practical implications, just based on who's in the audience right now, I'll use an example of what a DACA recipient has to consider when applying for law school, when deciding, okay, I'm going to go through college and then I'm going to go to law school. DACA recipients have shared time and time again that they can only plan their lives 2 years at a time. So a DACA recipient wanting to go to law school has to think through, okay, how do I practically make this work if I continue to have DACA, if DACA continues to be an option for me, and if I go back to being undocumented. So first you have to determine whether or not you will be admitted to a school. Law schools, when I was looking at law schools, I was still undocumented, and I found out that Pepperdine Law School doesn't admit you if you're undocumented. If you have DACA, they will admit you, but if you're undocumented, they won't. Then you have to determine, okay, how do I afford this, right? If you have DACA, you have the necessary documentation to maybe go to a bank and be able to get a private loan there to pay for your tuition. But otherwise, you can't get any benefits from FAFSA. You can't be able to, depending on what school you go to, what state that school is located, that'll determine whether or not you get in-state tuition, for example. That'll determine if the school can help you at all. But if you're undocumented, you don't have a social security number, you may not have proof of identity. So are you able to access certain forms of aid? And then once you get through law school, you have to think through, okay, to become a licensed attorney, what are the rules in the state that I live in? If you live in California, California has laws that have passed saying, regardless of your immigration status, you can get certain types of professional and occupational licenses, including a license to become an attorney. But what if you're not in California? What if you're in a different state where that's not an option? Then you may not be able to actually be barred despite already graduating from law school. And then you have to think through employment. If you have DACA, you have a work permit, you're able to use that to be employed. But if DACA is no longer an option for you, if you lose DACA because let's say a court order decides so, then you have to think through, well, as an undocumented person, can I be employed? Can I possibly become an independent contractor, which has a lot of restrictions and limitations? And that's just an example of how someone who's undocumented has to think through life choices and plan for scenario A, B, C, et cetera, right? And having DACA has been a blessing and has opened a lot of opportunities and doors, but there's still that limitation that it's only available 2 years at a time with no guarantee that it'll be available for renewal because we just don't know what's going to happen in the courts. And that's why it's very important for us to have legislation that finally gets passed that provides a pathway to citizenship for individuals so that way they can make life choices irregardless and not dependent on their immigration status.
Thank you for that. And thank you. You also delved into what was going to be another question of mine, which was about some of the ways that even DACA status can be limiting, right? I mean, it's certainly a really important set of opportunities for those who've been able to qualify. But yes, it's 2 years at a time and generates still a great deal of uncertainty. Anybody else want to take up sort of further reflections on some of the limits to DACA status? I mean, it was never really intended to be a permanent solution, and why it doesn't, work ideally as a semi-permanent one. I mean, even putting aside that now it's not one thanks to this ruling.
Just briefly, you
Roshia.
can't sponsor.
Go
You
ahead.
can't sponsor your family. Just that, you can't sponsor your family. And so when Nina's talking about these deep divisions in families, I mean, I've seen the same thing. It's so heartbreaking to be in a family where some people have status and some people don't, and it changes everything about your life in so many ways. Like you travel, what kinds of plans you make, the reasons Ignacia is saying, but thinking about all those in the family level. And family reunification has been a very important principle in our immigration law for a long time, and DACA is not doesn't give you that.
Okay, I have another question, which is coming from an audience member. The audience member is wondering if immigration provisions aren't included as part of the reconciliation package. What are the bills, either comprehensive or piecemeal, that are currently in the pipeline that might address these issues, and how viable are they? And I guess I'd love to invite you to answer that question, which came from an audience member. But then also, what would you, to put on your pragmatic hat, if there isn't filibuster reform and it's not done through reconciliation, is there a shape of a bill that you think could get through Congress and get passed, and what might that look like? So both the audience members' question, which is sort of about what bills are in the pipeline and their viability, and then your your analysis of what might be viable, whether or not it's in the pipeline now.
Well, I mean, there are, others can jump in on this too, but there are various legalization bills that where you'd have different groups of beneficiaries, right? So you have DACA recipient population with TPS, and so they're combined in something called the Dream and Promise Act. There's also a so-called essential workers, which could be the definition of essential workers, as Ignacia alluded to, could be adjusted in some way. We also have a bill that this is really the bill that would legalize not everyone, but it would be a much larger population of people. This is all wrapped up, I think, not just in the merits of these bills, but sort of partisan battles over whether this is identified as part of some Republican, some Democratic Party agenda. I think there's a bit of an effort on the Republican Party to cast the Democrats who may be voting in favor of some of these bills as open borders people. I don't think that's fair, but but I think as you get to larger and larger groups of people, and not just the number of people who acquire legal status, but also acquire eligibility for citizenship over time, that you're going to have ever diminishing chances of passage. I mean, that's just kind of what it looks like from 40,000 feet.
Thanks. Anyone else? It's really, helpful, and I don't know whether it's encouraging or discouraging, but any other thoughts from any of the rest of you?
I think it's interesting to think about the sort of scope of the possible also by way of what administrative actions can take place. For example, the TPS population, the Biden administration could very aggressively use the TPS power to grant protection. Again, it's imperfect, right? It's these sort of temporary protections. TPS status lasts a maximum of 18 months, but they do provide work authorization and they can be renewed. There's no limit on the number of times they can be renewed. And that's something the Biden administration could do to protect a large part of the population that also would be protected more permanently, obviously, by an essential worker bill or a farm worker bill to some extent. There's a very good case to be made that a number of the countries, particularly from Central America, which have very large populations of people here, are deserving of TPS, temporary protected status, because there's a lot of problems in those countries. So I think that's another option if the legislative path is not clear. I also think, I mean, I can just give you a teaser, but you're at the Center for Immigration and Law Policy, we think there's other ways that things that states could do, much more proactive and aggressive, you could say, by way of immigrant inclusion than what has been done in the past. Ignacia talked about how she benefited from, I'm not sure if you specifically did, you were talking about the fact that one would benefit from in-state tuition and certain other rules in California, obviously driver's licenses. But in my mind, they're just kind of scratching the surface. I actually think there's a lot more that state and local governments can do to include immigrants in ways that really can have a lot of the benefits of legalization, even though perhaps it's not the same as legalization itself. Yeah, just like a teaser. Hopefully some of those coming in, things that maybe could be done at the state and local level, which means in these places like California and New York, which are very sympathetic to DACA and TPS and things like that, where there might be purchase in the governments to actually move those ideas forward.
Thank you. I want to invite a sort of broader cultural reflection question, and then we can, come back to some of the sort of in the weeds questions about this. But I mean, so we're at this moment. I mean, we've talked about essential workers, right? We're still living with the pandemic and dealing with it, and there's no question but that enormous numbers of undocumented individuals played a really important role in being frontline and essential workers during this period, and that's impacted how some folks think about these questions and their senses of fairness and what we ought to be doing. And simultaneously, there's been, the border issues, the wall, the claims about the wall, the crises on the border, and the unease that this that if we're more open in our immigration policy, that the numbers will be unmanageable and unworkable and very harmful to those who are here. I mean, these are both kind of like cultural leitmotifs in the air, right? How do they affect what's really politically possible to achieve in terms of legislation or opportunity? I mean, are they, or do they? It's kind of a broad question, but I'd love any of you to address it. I'll take volunteers or I'll cold call. Okay, Hiroshi.
Yeah, this is something that, you know, that I've been thinking about quite a bit, and let me just raise 3 points and see what everyone else say about this. I think about larger issues in the cultural moment. A few things. One thing that I was reminded of when Ahilan was speaking about the role of states is it's not just the state versus federal government, but I think we have to find ways to break the partisan logjam. You know, that all of a sudden we can't talk about immigration issues as an immigration issue anymore. It's really about who's going to have a win, who's going to feel that they've lost, who's going to, you know, how people are jockeying for the midterm elections or the presidential election in 24, things like that. So I'm looking for ways to break partisan logjams. Another thing is Jennifer, what you're saying about essential workers makes me realize that, you know, we've developed a system in this country where we have people that I think a lot of people would regard as essential workers, but have no way to legally come to the country. So for all the talk we have about legalization, which I think is very important, what happens when you legalize people is that maybe people will be having the same conversation in 20 years because we didn't actually change the system. So there has to be some rethinking of the mission system to both match up the needs of the economy with the immigration system, but also to kind of think about how to spread the gains that immigration creates for the economy as a whole, to minimize a sense of displacement that some people may feel and that may create political opportunities against immigration. And the third thing is to pay more attention to why people leave the countries they're leaving and to work in a much more cooperative way with the countries that people are leaving, and in some cases fleeing. And this is not a question of sending a little money to another country and then being shocked if it doesn't have an effect in 6 months or 2 years, but it really is a long-term effort. But it's an effort that has taken place in other parts of in other times in history. And I think that in all the immediate attention to legalization is very important. It's important to think about really how we got to a situation where we know that that 10 million people in the country without status is really a known consequence of the system we've had. And the only way to rectify that is not to legalize people, not just to legalize people, but also to rethink the system that got us to this position. And unless we do that, people in the year 2040, or our children or grandchildren are going to be having the same conversation.
I wanted to just make one very discrete point, definitely not quite that big picture, but just about how all of this makes me think about the extreme importance of work authorization and how much all of this links to labor, because I really do think that I worry a lot that short of legalization, when you have things like some of the things going on right now in the immigration court system, where you have a lot of people who are no longer in removal, but are being put into these kind of just prolonged states of limbo. And, you know, you also have that to some extent with TPS holders who have been uncertain. You know, you start to see really just a recipe for exploitation. And DACA, I was looking at some statistics about the incredible wage change when people got work authorization. Their wages went up like, I had it written down, but, you know, like double, because they could get out of the underground economy. And so I think that piece, and, you know, Hiroshi's point about how you could separate work authorization and just have this about forbearance from deportation, I think that's exactly the direction we don't want to go. Like, we need to get people into positions where they can actually have some rights in the workplace and obviously in other places as well. But I think that's a really key piece.
Thank you. No, that's incredibly helpful. Ignacia and Ahilan, I want to give you, we have about 1 minute left. So I want to give each of you, since we just heard from Hiroshi and Nina, a 30-second chance each for last words that you want to share with the audience about what you think is kind of one of the most critical issues looking forward to think about in this space. So 30 seconds. Ignacia, you're up.
Thank you. So I really like the fact that Al-Hilan brought up like what can states do, right? And so we did include in the chat a resource we have at NILC that goes over like what can states do to minimize the harms of losing DACA, TPS, whatever the next immigration relief that's temporary is called. And it's important for states to think of it. And since this is UCLA, it's important for institutions to also think through like what can they do? What are they doing and can they do more? And UCLA already does a fantastic job of really helping and supporting immigrant youth and their families, but always worth looking into like if more can be done, if the DACA program were to end, can students continue to, for example, do work study, get certain types of scholarships and opportunities on campus? Can they continue, for example, as a graduate student, being able to serve as TAs? So, lots to think about, and it's opportunities for not just asking what can the federal government do, but also what can the state and institutions do as well.
Great, thank you. And yes, really important. All right, Al-Hilan, you get the last word.
I think the combination of what Nina and Ignacia said caused me to say a little bit more. I think that we need to explore state and local employment authorization. That's an idea that the center is very interested in, and the idea that as Hiroshi said, the Supreme Court says letting people stay here may be okay. That's forbearance. Giving them immigration benefits, meaning employment authorization while they stay here, the court suggests may not be okay, because you put those two things together, then you get sort of immigration status. So, one idea is we know, unless there's like a massive registry that is passed or something like that, which, who knows, anything's possible, but unless it's passed, there's going to be a lot of people left after whatever this legislative cycle is, who are going to be left undocumented. And maybe the idea should be, is there a way to get those people work authorization, even if they don't have a guarantee against deportation? Is that something that can happen at the state level? And that's something I think we're very interested in. I hope we'll have the chance to develop that more. What I really hope is that you get massive federal legislation that solves the irrationalities of the immigration system. But in the absence of that, I think that's a really important idea that we have more thinking to do on.
Terrific. Well, thank you. Thank you to all of our panelists for their insights and for being with us. We're very excited about what we're doing at UCLA with our Center for Immigration Law and Policy and all of our related immigration activities. It's a pleasure to get the chance to talk to you. And to our audience, thank you for being here, and thank you for the excellent questions as well. Take care, everybody, and have a good afternoon.
Thanks, everyone.